typically when the man dies, he hasn't signed that consent. So how do you achieve it? Well, the first problem is who does this work? And there's only one hospital, women's, where this is commonly done, and one doctor who commonly does these retrievals. The Human Tissue Act in Victoria governs the procedure, and the Human Tissue Act allows for pre-death, or they describe it as non-responsive retrievals. And the non-responsive retrievals requires first the approval of the medical treatment decision maker, typically next of kin, the widow, or soon to be widow I should say, and the designated officer of the hospital, typically the medical superintendent. Then, once you've got that in place, 2 doctors have to sign off on it. Each of them has to be at least 5 years admitted, and neither must be the designated officer. And it must be in circumstances where death would occur if the artificial respiration or artificial circulation was turned off. And there mustn't have been any objection to ante-mortem, as they've described it, procedures, the non-responsive procedures by the deceased. So those are the requirements for the pre-death, non-responsive. If the man has died, then there's always the rush to get it done quickly, and depending on how the body is stored and the health of the deceased, it may need to be done quickly within 24 hours. And there's a temptation by lawyers to go off to the Supreme Court and get an order. Generally, that isn't required if the procedure under the Human Tissue Act, I should say, is followed. However, I have seen cases where the man died via suicide and the hospital may require authorisation from the Supreme Court that it's appropriate to retrieve. It's not part of the legislation, but that's one of the practical barriers. And the practical barriers are finding a doctor and finding a scientist.